Hello everyone, welcome to Sunya IAS and welcome to this lecture. Today we are going to talk about a very broad topic, very interesting and broad topic. This is the concept of constitution. And trust me on this, that for UPSC Prelims, conceptual questions are very, very important, right? I would say conceptual questions can even be considered more important than theoretical questions now, because UPSC is now trying to understand whether the person has understanding of what they are studying, or are they just rattafying, and are they just trying to memorize things and clear the UPSC examination. So UPSC prelims is supposed to be handled conceptually, and to have that conceptual understanding, you need to understand the basics of Indian constitution, right? So you need to understand the salient features of Indian constitution, right? When we study the salient features, we will see that we will be able to know a lot of doctrines. We will be able to know a lot of various terminologies that are to be used in formal terms. So we will study. First, we will revise everything that needs to be revised. And the questions that will be asked from this area, they will be conceptual in nature. So they will be related to current affairs. They will be related to certain doctrines that have been in news, right? But we will be revising M. Laxmikant chapter, which is called Salient Features. So let's just quickly revise that. When we study the salient features of Indian constitution, we have to see that we need to have some terms on our fingertips. So for example, when you want to know the salient features, you straight away go to the preamble, right? That is the most basic way to remember. What does the preamble say? Say with me. Sovereign, socialist, secular, democratic, republic, right? We will be studying preamble in a separate chapter, so I will not be explaining all of these right now. But all of the words mentioned here, they are salient features of our Indian constitution in itself, right? So this is one way. The next thing is we will start writing one after the other. So the first feature is that Indian constitution is the lengthiest written constitution in the world. You are well aware of that. And when you get such a question in prelims examination, wherein an extreme statement is given, then the majority of the people now are well aware that extreme statements are not to be chosen. But here, this is an extreme statement that it is the lengthiest written constitution, and no other constitution in the world has so many articles, has so many schedules, or has so many parts as Indian constitution has. Here I would also like you to revise that how many articles, parts and schedules we had in our initial constitution. This is the way we keep on revising. So we had 395 articles, right? Right now we have 470 articles. Okay, so you plus 75 over here. Then initially we had 8 schedules. Today we have 12 schedules. And initially we had 22 parts. Today we have 25 parts, right? So this is the lengthiest constitution. So I hope you understand. Now, the next thing is that this constitution has been borrowed from various places. And this needs an entire 5 to 10 minutes chapter in its own right, because these kind of questions have often been asked, that from where have we borrowed which provision for our Indian constitution, right? So be with me, because I will be making you revise and understand everything related to this particular aspect. So the first and the biggest inspiration is Government of India Act 1935. and this is one of the criticisms of our constitution as well, that majority of the provisions are as it is when it comes to the Government of India Act of 1935. So first thing, let's go basic. The post of governor, you must be remembering that it was established by the governor of Bengal was designated as Governor General of Bengal in Regulating Act of 1773. We have understood that. So the post of governor is taken from Government of India Act 1935. Fine. Then our judiciary, right? Our structure of our judiciary, that is independent yet integrated judiciary, is also taken from Government of India Act. If you remember, Government of India Act called for creating an imperial court, that is the Supreme Court of India, right? That is there. Another thing that we have taken from here is public service commissions. Now, here you might be wondering that we also studied that the Government of India Act 1919 also called for starting a public service commission. Yes, it did. Yes, it did. But we do not consider it a source because Government of India Act 1935 built upon Government of India Act 1919 after the Simon Commission. Another thing, emergency provisions. Now here I want you to differentiate. The emergency provisions are taken from the Government of India Act, but the suspension of fundamental rights, during emergency, that is taken from the Weimar Republic of Germany. This feature is taken from Germany, but otherwise emergency as a concept is taken from Government of India Act 1935. And there are extensive administrative details that are taken from this. We are not going to go into the details of it. But please understand that Government of India Act 1935 is the biggest source of our Indian Constitution. So if you are clear with this, the next source that we need to understand is the British system of government, right? That is the British Constitution. First of all, Britain does not have a written constitution. You know that every law that they enact becomes a part of its constitution because it does not have a written constitution as such. So from the British Constitution, the very first thing that we have taken is rule of law. Rule of law. The concept of rule of law we have taken from British Constitution. Then a very basic thing, parliamentary government. Now within the parliamentary form of government, you also take various other names such as the cabinet form of government, right? The cabinet form of government. And here I would also want you to recall which act actually created the cabinet system, the portfolio system in the evolution of Indian Constitution. That was the Indian Constitution Act of 1962, 61, 62. Okay. Another thing that we have taken from British Constitution is the concept of single citizenship. This concept is not there in US, right? So you would know that UK is a unitary form of government. US is a federal form of government. So single citizenship is a feature of the British Constitution. That is, people are a part of only Indian citizenship. People are not separate citizens of their states as well. Fine. Then we have the concept of writs, right? And these writs are called prerogative writs. Historically, the purpose of these writs was to protect the immunity and to protect the word of the king. But we'll talk about it when we talk about fundamental rights. But writs का concept हमने British Constitution से लिया है. Then the concept of bicameralism as well. The concept of bicameralism, that we have a lower house, that is Lok Sabha, and an upper house, that is Rajya Sabha, we have taken from the British Constitution. Although this concept is also there in the US Constitution, but we have a model that is closely resembling the British model. That is, the lower house is the House of Commons, and the upper house is the House of Lords in Britain. Okay, so this is there. Another thing that we have taken is parliamentary privileges. Parliamentary privileges. Okay, so parliamentary privileges, historically they have been a part of British way of life, to enable the parliamentarians to say whatever they want, to do whatever they want on the floor of the house for lawmaking. And this is there in Article 105 for the central government. Fine. So overall, the confusion mostly arises when you have provisions like emergency, right? And you have things like Government of India Act 1935 and the British government. So that is the time that you get confused. So here you should remember this, that emergency was taken from Government of India Act 1935. Now let's move on to the third aspect. Let's move on to US, United States of America. The biggest thing that we have taken from here is the fundamental rights. No prizes for guessing that. Okay, so we have taken the fundamental rights from the US Constitution. Second thing that we have taken is preamble, right? The US Constitution also starts from a preamble. Our Constitution also starts from a preamble. Third thing that we have taken from US is the concept of judicial review. Please remember this. We have not taken this from any other country, but from the United States of America. The US court is considered the most powerful court of the world, and we have taken our Supreme Court's model and the High Court's model on the basis of US. That means the the courts can declare any law and even their own judgments as null and void. So judicial review is there. Then another thing which is very important is the concept of presidential impeachment. Now we don't have a presidential form of government, but our president can still be impeached, and that concept we have taken from the United States of America. Also, we have taken the removal of High Court and Supreme Court judges from the United States of America. Very important provision, right? The removal of High Court and Supreme Court judges. Also, this is a highly expected question. The post of Vice President. The post of Vice President we have taken from the United States of America. Clear? Other than that, there are a few things that equality before the law, equal protection of laws, right? Eventually, we did take due process of law also. But overall, these are the things that you need to remember. Moving on quickly, we need to remember what we have taken from the Irish Constitution. So most people are aware of the DPSPs that we have taken from the Irish Constitution, but we have taken more as well, which is very important. The fact that we nominate 12 members to Rajya Sabha, this aspect we have taken from the Irish Constitution. Very, very important. And please remember the basis on which these members are nominated, that is LAS. Literature, Art, Science, Social Science. You will be able to remember. Fine. That is there. Then another thing and a very important thing is the method of presidential election. Right? So presidential impeachment we took from US. Presidential election we took from the Irish Constitution. Ireland, right? You would be knowing that Republic of Ireland and North Ireland are two different countries, right? Northern Ireland is a part of the United Kingdom, and the Republic of Ireland is an independent country, right? So here the Irish constitution comes into the picture. Okay, then moving on to the next and a very important aspect. See, our federal model is very much in news. Okay, so it's very important that we understand where it comes from. So from the Canadian constitution, and Canada has been very much in news as well because of the Nijar controversy and Khalistan issue. So Canadian constitution say we have taken our federal model. How? Because our federal model has a unitary bias. It has a unitary bias. Our center is stronger than the states that we have. So that means our Canadian constitution, we have also taken residuary powers to the center. We all know that under the 7th schedule, the residuary powers are given to the center, right? Even this provision we have taken from the Canadian constitution, and this is a corollary from the federal model. When the center is stronger, it is supposed to have the residuary powers. Okay. Then another thing which is related to the federal model only is the appointment of governors by center. Appointment of governors by center. There is a highly expected question on governors, right? Because governors have been holding on to the bills that are being given to the states, that are being given by the state legislative assemblies. So this is a highly expected point, that from where have we taken the appointment of governor by the center, because of which governor is often termed as a, think about it, it's a negative terminology. Governor is often termed as an employee of the center. The reality is that it should not be like this, but it is like this, right? So employee of center or governor is also called a political football, if you remember. This is not important for your prelims at all. I'm just mentioning it so that you can relate it a bit better. Okay. So appointment of governor. So these three things will be easily remembered because they are related to the federal model. Another thing is the advisory jurisdiction of Supreme Court. The advisory jurisdiction of Supreme Court is also taken from this particular Constitution of Canada. So here you must be remembering that there are two types of advisory jurisdiction of Supreme Court. There is one where the Supreme Court acts as a court of giving advice to the lower courts, right? That is always there. But constitutionally, the President of India is empowered to seek the Supreme Court's advice on any matter under Article 143. So this 143 is taken from Canadian Constitution. I hope you will remember this. Okay. So this is something to remember, that mostly everything is related to federalism when it comes to Canadian Constitution. One thing is related to the Indian judiciary. Okay, moving on. Now we have small aspects which are kept. We can keep it on the same page as well. So let's come to the Australian Constitution. From the Australian Constitution, you would be remembering Australia because we lost a World Cup to Australia recently. So please remember, from the Australian Constitution, we have concurrent list, right? The list number 3 that is there in the 7th schedule, we have taken that concept. We have not taken this from Canada. Please remember, it is very easy to get confused over here, but concurrent list is taken from Australia. Then another thing is joint sitting of the two houses of the parliament is also taken from Australia. And here I would also like to remind you that there is one kind of bill there is of course the money bill to over which Rajya Sabha has no power at all to stop it or to pass it. It can just delay it by 14 days. But there is also constitutional amendment bill wherein there is no written provision for joint sitting. That means joint sitting cannot happen for constitutional amendment bill. Okay, this is a flaw. This is a loophole in our Indian constitution. Okay, so this is there. Another thing that we have taken is freedom of trade and commerce. This is not that important, still something that you must be knowing. Freedom of trade and commerce, right? This is Australia. Regarding Germany, Weimar Republic of Germany, I have already told you, I will remind you here again that suspension of fundamental rights during emergency, not the provisions of emergency that we have taken from Government of India Act 1935, but suspension of fundamental rights during emergency we have taken from Germany. Okay. Then former USSR, that is the Soviet Union. It was a communist state. So the primary thing was duties. People had to perform their duties. So fundamental duties added in the Indian Constitution through the 42nd Constitutional Amendment Act, also called the mini constitution. Always don't restrict yourself to the point of the information. Whatever information you have in your mind regarding this particular topic, you should be having it immediately. You should be speaking it out. You should be writing it while revising it. Okay. So fundamental duties 42nd Constitutional Amendment Act से add की गई थी. बाकी another thing which is important is in the preamble, the concept of justice, social, economic, political. Social, economic, political approach भी होती है आपकी when you're writing mains answers. So social, economic, political justice we have taken from USSR. Very, very, very important. Please remember this. Okay, USSR. Then from South Africa, we have taken a very important thing, and I will just tell you the article. The article is 368. Okay. The article is 368, and this article is talking about how to amend the Indian Constitution. So the amendment procedure taken from South Africa. Another thing which can be confusing is the method of elections in Rajya Sabha. So please remember the differentiation. Nominations in Rajya Sabha taken from Ireland. Elections in Rajya Sabha, proportional representation by single transferable vote, taken from South Africa. So these are the nitty-gritties which will stay in your mind after you revise. And finally, from Japan, we took the concept of procedure established by law. Procedure established by law means that anything that is written in the legal document of a particular country, if a process has been followed in consonance with that legal document and every legal formality has been followed, we will not check whether the law is correct according to principles of natural justice or not. We will just see that whether it has been followed or not. So we took it from Japan. It is mentioned in our article 21, procedure established by law. However, in the Menaka Gandhi case, and for the Minerva Mills case, etc., it was said that it is not just procedure established by law, but we do follow the due process of law. That means it's not that it's not just ki we follow a law and the law has to be just followed. The law has to be fair and just as well, according to the principles of natural justice. So I hope the sources are clear, and there is no doubt when it comes to the sources, because it is very important that you remember these sources. So now we were talking about the features, right? So lengthiest written constitution, borrowed from various sources. The third thing about our Indian constitution is it establishes a parliamentary form of government. A parliamentary form of government, right? So now you know what is a parliamentary form of government, that you elect people constituency wise, and from within these people, your government is elected. You do not vote separately for the president or the prime minister and for the legislators. You vote just once and the legislatures choose the government. So that is your parliamentary form of government. The fourth feature is a unique federal model. We will talk about all of this, okay? We will talk about all of this. The unique federal model which we took from Canada, right? Strong center. The fifth aspect is we have a blend of rigidity and flexibility. I hope you know what it means, that our amendment process is very, very unique. Okay, Article 368 allows us to amend our Indian constitution in two ways, and apart from that also we can amend it in another way, that is simple majority. Okay, then a very important thing from which a question was asked was, we have parliamentary sovereignty. Listen to this very carefully. Parliamentary sovereignty coupled with judicial supremacy. And here a confusing mains question has been asked, which is about parliamentary supremacy and sovereignty, and other concepts around it. So parliamentary sovereignty basically means that we are independent. Our parliament does not depend on the British Parliament anymore. We are independent. And judicial supremacy means that parliament is not supreme. Parliament cannot break the constitution itself, and that was made clear by the Kesav Nanda Bharti case. If you remember, Kesav Nanda Bharti case brought about the basic structure doctrine, and the basic structure doctrine says that you cannot finish the basic structure itself of the Indian constitution. Right? Chalo. Next thing, when we talk about the parliamentary form of government, we have two kind of executives. Of course, we have three organs of the state. That is very clear: the legislative, executive, and the judiciary. Right. So the kind of questions that are asked in prelims. For example, a question was asked about committed judiciary and committed bureaucracy. Right. So if we talk about the executive, if we talk about the executive branch, there is two kind of executive. One is political executive, that is the ministers, and one is the permanent executive, that is something that you all are aspiring for, that is the civil servants, right? The permanent executive, the bureaucrats. So a term was used here which was called committed bureaucracy. And committed is not being committed to the constitution, right? Committed means committed to the political leaders. So committed here is a negative term. If it is used for the Indian judiciary, if it is used for the Indian bureaucracy, it is a negative term. Our bureaucracy or judiciary is not committed. It is a constitutionally bound judiciary and bureaucracy. So we do not have a committed bureaucracy. Please understand that if it is asked in your examination. Okay. All right. The next thing that is a primary feature of our Indian constitution is a integrated and independent judiciary. So we are integrated because our central and the state courts and the lower courts are all functioning under the Supreme Court. Everything is under the Supreme Court, right? This is unlike the judicial system of the US, wherein there are separate courts for the states and the center, the federal court. And independent because again it is a non-committed judiciary, no influence by the political elite. Okay. Then some basic features are fundamental rights, fundamental duties. We will cover them in separate chapters. DPSPs, nothing to tell here. I have already told you fundamental rights we got from US, duties we got from Russia, and DPSPs we got from Ireland. Okay, so nothing to tell over here. Then if we go to the preamble, I have already told you sovereign, socialist, secular, democratic republic. Another very important feature is universal adult franchise, which is constitutionalized in India. Universal adult franchise, which is constitutionalized in India under Article 326, and we will talk about it that earlier, before the 61st Constitutional Amendment Act, anyone and everyone under 21 years of age was allowed to vote for any election of India. Now that age is 18 years. Okay. Then another very important feature is emergency provisions. You should be knowing the part, the emergency provisions, right? The part is 18. How will you remember it? Because as soon as you turn 18, there is a lot of emergency to create your driving license, to create your voter ID card and everything. So 18 is for emergency. I hope you will remember this. Moving on to the next feature, and it is a very unique feature of Indian Constitution. See, in Indian Constitution, we have certain independent bodies, right? We have certain independent bodies, and mostly in democratic constitutions, such kind of bodies are created by laws. They are not established by the constitution itself. What are these independent bodies that we have? We have the Union Public Service Commission and State Public Service Commissions, for which you are preparing right now. Then you are having Election Commission of India. Also, you are having the Comptroller and Auditor General of India. So these are the independent bodies which keep a check on the executive. So they are called the bulwarks of democracy. And this is a unique feature of Indian Constitution. Another important feature is that we go for single citizenship. Now, single citizenship has two connotations. When we talk about it as a feature, we talk about it in the federal terms, right? So, in federal terms, we are only a citizen of India, not a citizen of particular states like Haryana, UP, like Andhra, etc. We are just Indian citizens. Another meaning of single citizenship can be construed as no citizenship of another country. है ना? No citizenship of another country. Now this is, yes, one of the features, and we will talk about it in citizenship chapter. But right now we are talking about single citizenship. So I hope that is very clear. So from prelims perspective, all of these features are very important. They can be asked one way or the other. And now let's go on to the question solving, where we will be showing you a question. You will be pausing the video and you will be answering the question. Okay. So first question. What principle ensures that individuals have a responsibility to participate in the functioning of their government and uphold its democratic values? Judicial review, popular sovereignty, implied powers, or habeas corpus? So the answer to this is, what do you think? The answer to this will be, of course, popular sovereignty, which is a part of our preamble as well, and which clearly says that it is going to be the people of India, we the people of India, who will solemnly resolve to enact, adopt and give to ourselves this constitution, right? So popular sovereignty means that individuals have this responsibility. Judicial review is not applicable because judiciary is not elected by the people. Implied powers is not applicable over here. Habeas corpus is a writ, right? So it is not applicable here. Moving on. Question number 2. A public authority's failure to give notice to an applicant before taking a decision that adversely affects their legitimate expectation is likely to be considered a violation of which one of the following principles? Your options are principle of reasonable expectation, principle of locus standi, principle of promissory estoppel, or principle of double jeopardy. Okay, so the answer to this one, many of you might be thinking that the answer is B, locus standi. But the answer is not actually locus standi. The answer here is the principle of reasonable expectation. Now, please understand. When we talk about locus standi, we talk about judiciary and the fact that only those people who are impacted by the particular decision that is being taken by the judiciary can petition against that particular decision. So only those who are impacted. The principle of locus standi came a lot into news with PIL, public interest litigation. Why? Because PIL relaxes the principle of locus standi. That means anyone who is not affected by a particular law as well can also go for filing a case, right? For mass welfare, etc. Then principle of reasonable expectation, as it is very clear by the name itself that if authority, let's say, is going to take away your property, right, because they have to create the railways, they have to create something, etc. So at that point of time you are being affected, right? So it is a reasonable expectation that you will be informed about it, right? So that this is there. That is why you see that any executive decision that is taken, let's say factories are being shut or shops are being sealed and all, so they will always inform, right? Principle of reasonable expectation. That is a reasonable expectation from someone. Principle of promissory estoppel means that it is basically used in contractual terms, right? So if there is a contract and that contract was signed, a promise was made, then it is reasonable to expect that this promise will be upheld, and the party can recover whichever promise. Let's say there was a promise that and the promise wasn't written, that let's say if within 5 years a company is not able to give at least 10% per annum rate of return, then a lump sum amount of 50 crore will be given to that particular investor by the company. This was a promissory estoppel. So the investor will be eligible to recover this 50 crore rupees from the person. This is promissory estoppel. And double jeopardy, we all know. Double jeopardy basically means that no person shall be implicated for the same crime twice, right? And in which article is it mentioned? There is always a confusion to people that whether it is article 20 or whether it is article 22. It is article 20. Please understand. Okay. Article 20 has three principles. Double jeopardy is one of them, right? No double jeopardy. What are the other two principles? No ex post facto. You can jail someone, you can punish someone only for a law breaking. That law has to be there in enforcement. Then no self incrimination. You cannot be a witness against your own self. And no double jeopardy. These are the three principles. Okay. So these are the principles which are applicable for people who are being arrested. 22 has principles for people who are arrested actually, right? So we'll talk about that in fundamental rights. Next question for you. A law passed by Parliament contains a provision that infringes upon fundamental rights of the citizens. In this context, which doctrine allows the court to declare only the offending provision as unconstitutional while keeping the rest of the law intact? Okay, so here you can see that it is the doctrine that is being asked. So your options are doctrine of separation of powers, doctrine of judicial review, doctrine of severability, doctrine of state decisis. What do you think the answer is to this one? Okay, so first, please understand the context for which this one was in news, this particular doctrine. And your UPSC prelims increasingly are having these kind of questions wherein doctrines are being asked, wherein concepts are being asked. So the context was 97th Constitutional Amendment Act, wherein cooperatives and the right to create a cooperative was given a fundamental position, a constitutional position, a fundamental position. Now, here, the central government, the parliament had actually enforced this 97 Constitutional Amendment Act, but cooperatives as a subject are a part of state list. The only part that the center could make a law was the interstate cooperatives. Okay. So what happened? What happened was that Supreme Court said that interstate, the 97th Constitutional Amendment will be partially upheld. So the cooperatives part of it, wherein the parliament has given, has tried to intervene in the domain of the state, that will be declared unconstitutional. But the interstate cooperatives part of it, which is in the which is the interstate part of it, which is in the domain of the center itself, that will be upheld. So, like there is a particular, what do you call severity? This is a particular dead body, let's say. If you cut it in pieces, you say that you have severed the head. Okay. So when you have a law and you are cutting it into pieces, you are declaring that this part is constitutional, this is not constitutional, this is constitutional. That is called doctrine of severability. Right. So which doctrine allows the court to declare only the offending provisions as unconstitutional? It is the doctrine of severability. So the entire act will not be null and void. It will just be the unconstitutional part of it. Okay. Next one. Which of the following statements best explains the concept of eminent domain in the Indian Constitution? The concept of eminent domain. It is the power of government to take private property for public use with just compensation. It is the power of president to remove any government official at will. It is the power of judiciary to interpret the constitution. And it is the power of prime minister to make executive orders. See, the doctrine of eminent domain means that whatever a particular authority is doing, it is in the power to do so. So authority, that is the state, and this eminent domain is also sometimes used in the federal terms, that what is the eminent domain of the center, what is the eminent domain of the state. So this question could have been come off as a little tricky question. The answer to this is A. It is the power of government to take private property for public use with just compensation. This is the eminent domain of government. This is something which the government is authorized to do and can do. Okay, so this is the domain of eminent. This is eminent domain doctrine. The third and the fourth one would have been a little tricky for you because they are also, judiciary also has the power to interpret the constitution and prime minister has the power to make executive orders. But I'm telling you that this particular eminent domain is used in center versus state debate or the discussion of government powers, that how much powers can the government actually enact, can the government actually use. Okay. Which of the following best reflects the principle of natural justice in the Indian Constitution? It ensures that all legal procedures are followed meticulously. It promotes a fair and unbiased decision-making process. It allows the government to take any action in the interest of the nation. And it grants individual the right to represent themselves in court. Okay, so the answer to this one, you would be confused in two options, I'm very sure. You would be confused in option B and option D. Okay, so whenever in prelims you get a 50-50 option, go for the more generic answer. Go for the more generic option which has less chances to be incorrect. You know what I'm saying? That the more generic option over here is that it promotes a fair and unbiased decision making process. Right? This can be a part of natural justice. This is very less likely to be incorrect. So go for this. Granting individuals the right to represent themselves in court is not something that comes under natural justice. It is an important legal right for sure. But many countries, many legal systems do not provide this, that you can represent your own self. Okay. So this becomes incorrect, and third is obviously incorrect. Government cannot take any action in the name of national interest. And one is also not a part of natural justice. Okay, what is this? What is this a part of? It is procedure established by law. Okay, procedure established by law it is. It ensures that all legal procedures are followed meticulously. Which statement, next question, which statement accurately describes the implied powers of Indian Parliament? Implied powers of Indian Parliament. So implied powers are explicitly mentioned in the Constitution. They are those that the Parliament does not possess. They are necessary to carry out expressly granted powers, and they are derived from state governments. See, the name itself is telling you that they are implied. So you can cut off the first one, that they are explicitly mentioned in the Constitution. You can also cut off the second one, that they are not possessed by the Parliament, because they are implied powers. But nevertheless, they are powers. Okay. Now you're left with two options: necessary to carry out expressly granted powers and derived from state governments. So Indian Parliament, please make a note, never derives anything from the state government. No powers are derived from the state government. So D becomes incorrect. Okay. The only role of state government is the Rajya Sabha elections, wherein the state government participates. Okay. So by elimination, which can still work sometimes in these kind of questions, you are at option number C. Okay. Next one. In the context of Indian Constitution, the procedure established by law implies A. Any law enacted by the government is a valid procedure. Then government can establish its own procedures without judicial review. Legal procedures must be just, fair and reasonable. And all legal procedures must be in conformity with the Constitution. So think about it. Okay. Here also you can arrive, although it is a very easy question, but let's say what we can eliminate. It gives you a lot of confidence when you are able to eliminate the wrong answers. So any law enacted by government is a valid procedure? No. This is an authoritarian government. Let's say tomorrow government says that we will not be conducting elections because elections, we are just scrapping the policy of elections itself because we can amend the constitution. No, that cannot be done. Then government can establish its own procedures without judicial review? No. Judicial review is a part of basic structure. Then legal procedures must be just, fair and reasonable. This and this you would have been confused. C is a part of due process of law. Okay, due process of law. So when you are there in pressure environment writing, marking the questions, it is very easy to mark even the basic ones incorrect. Okay, so due process of law is not to be chosen here because procedure established by law is being asked. So D is the correct answer, that all legal procedures must be in conformity with the Constitution of India. B, not sorry, D, not B. Okay. So D is the answer for this one. Moving on to the next question. The concept of equality before law in the Indian Constitution means all laws must treat individual equally. Every individual is equal before the law and has the same legal rights. The government can discriminate between individuals based on their characteristics, and the judiciary has the power, the authority to create laws. What do you think is the answer to this? Very easy question. Equality before laws means that every individual is equal before the law and has same legal rights. Okay. It does not mean that all laws must treat individuals equally, because even Article 15, starting from Article 15 Clause 3 to Article 15 Clause 6, it keeps on giving affirmative action to the sections of society which need it. So here there is no point of saying that all laws must treat individuals equally. Laws can treat different individuals in different manner. Okay, so first is incorrect. Second is correct. Third, government can discriminate between individuals based on their characteristics. This is true. This is not something that is false. As I said, 15.3 to 15.6, they are discriminating. But this is not the definition of equality before law. So you have to read the question very, very, very carefully to go forward with the answer. Because you can find correct statements in the options, right? You can find correct statements in the options, and those correct statements should not become your answer, right? The judiciary has the authority to create laws. This is not correct. This is against the principle of separation of powers. Okay, this is against the principle of separation of powers. So this becomes incorrect. Judiciary does not have the authority to create laws. Next one. In the context of originalism, what is the significance of original public meaning? Listen to this carefully. It refers to the interpretation of constitution based on the word's original intent. It emphasizes the interpretation of constitution based on the meaning that general public understood at the time of its adoption. It focuses on the changing societal norms and values in the interpretation of constitution, and it considers the amendments made to constitution over time. So please, if you are getting such a doctrine wherein you are not very sure, either you don't attempt the question in the exam, but if you have already attempted very less number of questions, then you have to take the leap of faith. Okay, so let's say this is a doctrine which is telling you about original public meaning. So it has three words. It is trying to understand the meaning of some law or something, right? We can assume that. It is going back to the original meaning, and it has the word public in it. Okay. So if it was just the original meaning, we could have chosen option number 1, that it refers to interpretation of constitution based on words original intent. We could have chosen this. But it also has the word public in it. So 1 becomes incorrect. Then it emphasizes the interpretation of constitution based on the meaning that the general public understood. General public understood. Yes, general public understood at the time of its adoption. So here two conditions are being fulfilled. One is the public aspect is being fulfilled, and one is the aspect of originality. That is also being fulfilled, that at the time of original adoption. So this can be the correct answer. Keep it in your cards. Then it focuses on changing societal norms and values in the interpretation of constitution. This cannot be the answer because the doctrine is saying original public meaning. Okay. So this becomes incorrect. Then it considers the amendments made to the constitution over time. Again, this is talking about the evolution. So here you are eliminating the rest of the options to arrive at the correct one. And here B is the correct answer. Moving on to the next one. Under the state decisis doctrine, which of the following is a situation that may lead to overruling of a precedent? The precedent is a long-standing and well-established legal principle. The precedent is consistent with the current societal values and norms. The precedent is found to be fundamentally incorrect or unjust, and the precedent was set by a higher court. So first of all, what is state decisis doctrine? State decisis doctrine means that if there is a precedent, that means, let's say precedent means that you have taken an action, and on the basis of that action, further judiciary, actions are being taken following in your footsteps, right? So for example, the Kesavananda Bharti case set up a big precedent for judicial review and even for judicial legislation. Okay, because judiciary created the doctrine of basic structure, right? So it set up a precedent. Okay, so state decisis doctrine says that in case of such kind of precedent, we can take the further decisions on the basis of earlier precedents. Okay, we can take further decisions on the basis of earlier precedents. This is the state decisis doctrine. Now, in what case the precedent can be overruled? Okay, here also you will be arriving through elimination. There is a precedent that has to be overruled. That means it has to be told that it is incorrect. So if it is a long-standing and well-established legal principle, why would it be termed incorrect? There is no point of it, right? So this is incorrect. Precedent is consistent with the current societal values and norms. Like recently, the Supreme Court said that same-sex marriage cannot be allowed. Okay, that is a part of that will become, it will become very difficult in our culture to accept it and etc. So it is a part of current societal values and norms. So why will it be overruled? It will not be overruled. So this is incorrect. Third one, if the precedent is found to be fundamentally incorrect or unjust, definitely it has to be overruled. So for example, let's say eventually whenever the collegium system will be replaced by something called National Judicial Appointment Commission, wherein some kind of executive influence can also come into the picture and the overriding power of judiciary can be reduced. At that time, it will be said that giving so much power to the judges is fundamentally incorrect or unjust, and that is why the precedent has to be overruled, right? And then the judiciary will use this particular state decisis doctrine. And if the precedent was set by a higher court, then it gains a lot of legitimacy. Then why it will be overheld? Okay, so here the answer becomes your C, and that is again on the basis of elimination technique. I hope you understand that. All right, moving on to the next question. The question asks, the rule of law in a constitutional government implies what? First option, the government has absolute power and authority. Then all citizens are bound by the law, including the government. Then the law is subject to interpretation by executive branch, and the government can suspend the laws in times of crisis. These are the four statements. Now, if you think about it, there is one statement that is completely incorrect. That is statement number 1. That is, government has no absolute power in a constitutional government. Constitutional government in itself means a limited government, right? So this becomes incorrect. Then come to the third statement. The law is subject to interpretation by the executive branch. First of all, in India, the law is interpreted by the judiciary. Okay, it is executed by the executive, right? So here, rule of law is not comparable. Rule of law is not defined by the third statement. Then the government can suspend laws in times of crisis. Again, this is a correct statement. But is it correct in context of the question that is asked? No. In context of the question that is asked, the rule of law means all citizens are bound by the law, including the government. So rule of law is an antithesis to the rule of men. Okay? Rule of law is an antithesis to the rule of men, which used to exist in the times of ancient and medieval kings. Now we do not have that anymore. We just have rule of law. So I hope that is clear. Next question. Which one of the following statements best describes the principle of due process of law in the Indian Constitution? It guarantees that laws will be applied fairly and justly. It empowers the government to enact any law it deems necessary. It defines and limits the power of the judiciary. And it ensures that all laws are consistent with international treaties. So just think about it. See, we have already studied that due process of law is a wider concept than procedure established by law. Is it correct? So just let's start with elimination. It empowers the government to enact any law it deems necessary. No, this is absolutely incorrect. So B is not correct. It defines and limits the power of judiciary. That is not due process of law. Okay. Judiciary's power is restricted by the constitution itself, by the impeachment of judges and various other provisions, but it is not anything to do with the the due process of law. So you will be confused between A and D. So always the rule that I have told you, when you are confused between two statements and you want to take the leap of faith because you have not attempted enough questions, always go for the wider statement. So among these two, which is the wider statement? That it guarantees that laws will be applied fairly and justly, right? D1 is narrowing it to international treaties. Due process of law, due process of law is a wider explanation, has a wider explanation than international treaties. Due process of law comes near the concept of principles of natural justice. Okay, principles of natural justice. So here you have again the same rule is applying. You have to choose the wider explanation. So A becomes your answer. I hope that is clear. Why A is the answer. Right. So now we have attempted about 12 questions today. And I hope you were able to revise the overall concept of our constitution. Lot of doctrines we revised. I would suggest that you go over the lecture again once if you want to. And if you want to complete your entire prelims preparation in a very systematic manner through 3000 plus MCQs, you can contact us on this particular number that is given. Here it is given, right? And you can go on the website also, so that you can get a systematic way of preparing for your examination. We'll be covering modern history through 400 MCQs, Indian polity already we have started, geography, economy, art and culture, current affairs, most important part of prelims nowadays, ancient medieval, environment, ecology and science and tech. So as you can see, all the prelims worthy subjects are going to be covered in this particular course, right? So you can go to our website, you can check out the link if it suits you. All right. So thank you so much for attending this class. I hope you derived some benefit out of it, and take care everyone. I'll see you all in the next class. Bye bye.